Go ahead, Jack.
Going back to this, what so-called President George W. Bush has been saying, hasn't he been saying that we have to create an interim government in Iraq? Now, what has America been led by since the War of 1860s?
Interim government.
We're
under a tutelage, just like we're putting Iraq under a tutelage.
Yeah, that's the interim government.
Yeah.
Now, this interim government also is claiming that they have guardian ad litem over all of us. Mm-hmm. Now, if you go back to look that guardian ad litem up, you'll see what that's got
to do with it. Well, who's the retired general that's the head of the resurrection of the Iraqi government? He's the ex-military head that's been appointed to resurrect the civil government, but he's the guardian ad litem. And if you'll remember that about a week ago there was some kind of a Muslim cleric who, by the force of his followers, claimed to be the mayor of Baghdad to assume a title of civilian government. Mm-hmm. And if you'll remember, in the last day or so, there was a notice that the American Army has arrested him and charged him criminally by trying to usurp an authority which he wasn't legally or lawfully given.
Right.
Obviously, he is in contempt of the wishes of the guardian ad litem trying to restart that economy.
And that's George W. Bush.
Yep.
Correct.
You got it.
Amen.
So what they're doing is they're showing you a mirror image of what happened to us over there in Iraq, for those that have eyes to see and ears to hear. Yep. Very, very interesting what's going on. Let's see. There was a couple of one very interesting thing. We have been talking about bonds and having the capacity of securing the bond in the court, criminal court, so that we have title in that criminal court. And remember, we said that he that controls the bond in the criminal court controls the case. Nick was going through the dictionary. Yeah, he's got a boring life. He reads the dictionary on the weekend. And he came across very, very interesting definition. Letter of undertaking. Everybody know what an undertaker is? A mortician? Well, it goes beyond mortician. Oh, let's see. We get well beyond that huge section of maxims. Back to undertaking. And to undertake is to take on an obligation or task. Like he has undertaken to chair the Committee on Legal Aid for the Homeless. 2, to give a formal promise or a guarantee. A guarantee is like an insurance policy, isn't it? And he that insures has highest title. To give a formal promise, guarantee, like the merchant undertook that the goods were waterproof. He's guaranteeing they're waterproof. If they get water soaked and damaged, he will pay the damages by his undertaking. 3, to act as a surety for another. To make oneself responsible for a person, fact, or the like. For instance, her husband undertook for her appearance in court. An undertaking is a promise, a pledge, or engagement, a bail, bond. Letter of undertaking. Listen to this. Listen up. An agreement by which a ship owner, that's the living soul behind the vessel, a ship owner to avoid having creditors seize the ship and release it on bond, agrees to post surety on the ship and to enter an appearance, acknowledge ownership, and pay any final decree entered against the vessel, whether it is lost or not. In other words, you're going to go into a court. Now, remember, when you're in an admiralty proceeding in the court, they got to have the bond to have subject matter jurisdiction over the proceeding, right? So in most criminal cases, they ask for the appearance bond. It's always on the liability finance side of the public, so the public holds the insurance policy, the undertaking on the case. And because they hold the undertaking on the case, what are the rules of prosecution? Public policy. You're the debtor. The state is the creditor. When you're coming in to secure that bond, if you can do the bond OR or PR without spending any liability-funded money, you're on the asset side of the account, and your insurance undertaking is on the asset side of the case, and then the case is not run under public policy, it's run under private rights, and you're the creditor. So look, remember what Victoria was saying? Man, if they know I'm the creditor, they ought to let me out. So you get wind that something's happening and they're going to prosecute the vessel, which is your straw man. Why don't you come into the court with a letter of undertaking, whereby your letter of undertaking, by way of the exchange of your consideration on your prepaid account through your exemption, you're going to underwrite all of the damages, whether the vessel is lost or not. When you do a letter of undertaking, what it does is it releases the vessel so it can go upon its journey, because you've replaced the vessel with the documentation of the letter of undertaking in its place. It's a surety. Isn't that basically what you're doing? If they won't agree toward issuing you the bond, you just issue a letter of undertaking for them. Now, I've got a lot of people out there, tutors, that have put in this bond, and almost verbatim, when you put the bond in, what does the attorney on the opposite side do? Move to strike it. Why do they want to move to strike it? It's too much truth. They can't stand all that truth in the case, so they move to strike it. What do? Totally accept it. Go ahead. Because if they strike it, the intent is still there. The letter of undertaking is there, whether they strike it off the left-hand side of the case or not. But if you argue about it, what just happened? You became the debtor by way of your dishonor, and now you have canceled your letter of undertaking. So you just fully accept what they're doing, because all they're doing is procedural to remove it to the right-hand side of the case. Who cares? It's still there. We had another guy that actually they were negotiating a settlement in a criminal case. And they got the settlement, they got the United States prosecutor to come out, and the U.S. prosecutor basically said, well, okay, if you do this, and this, we'll settle. So the guy did a full acceptance, and then he did all of the requirements. And then he requested of the prosecutor, by a nice letter rogatory, that the prosecutor go in and close and settle the account. And the prosecutor wrote back a letter rogatory to him that went also to the judge that said, we don't have to settle nothing. What just happened? A dishonor. Okay, now, this guy was thinking of going into the court, petitioning the court for a petition for dismissal based on that dishonor. A petition for discharge. Okay? And then this party talked with Cindy Beers out west, and Cindy said that there was a case that came down in which somebody was going to go into the court with a petition for a discharge or dismissal once they got the agreement or the dishonor and the certificate of protest from the other side. And then they just happened, before they did that, to run across some case law. And the case law said that if you went in for a motion or petition for discharge, that the court wouldn't have to grant it to you, because if you looked up the ramifications for discharge, you'll find out that by discharging something, what you literally end up doing is you ended up opening something else. And so by moving for the discharge, you didn't get the remedy. The answer is you go into the court and you seek an order of estoppel. Because the other party, by their dishonor, is stopped from moving forward or moving back. And seeking an order of estoppel from the judge in the court as the referee gives you the ability to prevent the other side from moving forward. See, now what happens is when the other side gets to the point where you ask them to follow through on what they said they'd do, are they going to follow through on what they said they're going to do? No. That's too obvious. They're agreeing with you. They can't agree with you because they assume you are the enemy, and they can't agree with the enemy. So what they do is they dishonor you. It's the reverse of what you think. Now, with that dishonor, if you go into court and you are the creditor and you honorably request of the court an order of estoppel, then the court, as the referee, comes forward, and the court merely says, yep, we not allow the prosecutor to do that, so therefore they're estopped, so therefore you go on and you get your remedy. But they do it by a request for an order of estoppel to take mandatory judicial notice rather than for a petition to dismiss or discharge, because that opens collateral issues which can raise more things where the plaintiff, the prosecution, can come back in and undo what their dishonor did. So these people are trying some of those things right now. Okay? Yes. On the mic, please.
A few weeks ago, you handed out this letter of advice from Sarah Fugate, and I was just down there. Where she lives is around Daytona Beach. That's the county that she's in. I was just wondering, and that it's Volusia County,
okay,
Florida. Does anybody down there have transcripts of this case, this court case?
We've had some transcripts that's come out of service in there that are selling them.
Is that the one you said for like $20, $25?
I think so, something like that, yeah.
Okay, and there was an address on that again that was on the last tape or whatever?
Could have been, yeah.
Okay.
Okay. Well, we're past time tonight. That's probably a good place to end. We've raised several very interesting and significant things in what we've done here tonight. A lot of them of which have just got to go a little bit farther in to get a little bit more background and updates as to what's happening, but definitely don't give up the ship yet. There's a lot of really neat things that are coming down. So, God willing, we'll be here then next Monday again. Thank you.